Hi, I'm Sergio Cabanas, attorney at law here in South Florida. Thank you for joining me today. Today's question for this video is, Sergio, what effect does a divorce proceeding have on a spouse who becomes disabled or actually dies before the divorce is finalized? Well, that's a very good question. And in fact, it was a hot topic, very controversial just a few years ago because of a famous celebrity couple. You may recall the case of a famous basketball player, Lamar Odom, and his then wife, Khloe Kardashian. They were very famous and they were in the process of finalizing a divorce in California. But that's when tragedy struck. Lamar Odom, a young, healthy athlete, was found unconscious from a drug overdose in a Nevada hotel. Well, that became very famous because he was hospitalized, and the only person who had legal authority to make life and death decisions on his behalf was the very wife from whom he was getting a divorce. That was a very scary and controversial issue back then. Now, it all worked out for them in the end. He eventually recovered. But that made everybody aware of these circumstances. Wow, here is a famous couple who don't like each other. They legally announced the fact that they no longer wanted to be with one another, and yet, because the divorce was technically not signed off in California, the wife still had complete decision-making authority over his medical treatment and making life and death decisions on behalf of a husband when it was clear they no longer wanted to be with one another. So of course, that question became so controversial and so interesting to me that I decided to research how Florida law would work under similar circumstances. So I've designed a chart to kind of explain the various circumstances under which this could play out during a divorce proceeding. And this chart is right here. So without further ado, let's go to my chart. So this chart starts with showing the three phases of a divorce proceeding. There's the pre-divorce, where the marriage is in existence. Then we have the divorce phase itself. And then finally, we have the post-divorce phase. When we think of a divorce under Florida law, it actually starts with the filing of a divorce, and it's a legal proceeding that finally concludes with a final judgment for the divorce. So there's a divorce phase here, which consists of filing the divorce and ending with the final judgment. Let's assume further that one of the spouses has an estate plan. That estate plan may consist of a will and or a trust, where a beneficiary is a spouse. So that's very common in a marriage at the time, and that's fine and good at that time when the marriage was intact. But over time, what happens? Well, it results in the filing of the divorce, and obviously the relationship starts to deteriorate before the filing of the divorce, obviously. But what happens is that during the marriage, these documents remain intact up until the divorce is filed. So what happens when the divorce is filed? Well, you're pretty much announcing legally and announcing to the world that the relationship has ended, and it's becoming obvious that you no longer would want your spouse as a beneficiary of your will or your trust. What happens under Florida law? Well, regardless of the fact that you filed a divorce, the spouse actually continues to be the beneficiary of your will and trust throughout the divorce proceeding up until the final judgment is entered in the divorce. Only then will the law presume that you no longer want your spouse as a beneficiary of your will or trust. Now, there's other documents that come into play with an estate plan. For example, we have a financial power of attorney. Maybe during the marriage, you named your spouse to handle your finances or certain financial transactions in the event of any incapacity or disability or sickness that may come into play. Well, in that case, even though the relationship deteriorated to the point you filed the divorce, the spouse remains as your agent under this power of attorney until the divorce is filed, and then it's deemed revoked. So in the case where you have a power of attorney, upon the filing of divorce, it ends here at the time of the divorce being filed. So you don't have to worry about that during a divorce proceeding. So that spouse can't do the financial transactions on your behalf. Now let's turn to the healthcare surrogate. Let's assume that you named your spouse as your surrogate to make medical decisions for you in the event of any disability or sickness to the point you can't make these decisions on your behalf. Well, when even though your relationship is deteriorating to the point that you're about to file the divorce, your spouse remains as your surrogate. And then what happens when you file your divorce and announce to the world that you are seeking to separate from the spouse and no longer want to be with your spouse? Well, believe it or not, throughout the divorce proceeding, the spouse remains as your agent if nothing's done to legally change it. Now let's move to a living will. Living will is a document that empowers another person to make life and death decisions about disconnecting you from life support if you're ever found in that situation. So you're basically naming someone else to make that life and death decision for you when you're not capable of making that decision. Well, in the event, again, during the marriage, it stays intact. And what happens when you file the divorce? Nothing. The spouse continues to act with that legal authority until the divorce is finalized. So going back to the story between Lamar Odom and his then wife, Khloe Kardashian, that's what happened. The California court had already processed the entire divorce proceeding, but the judge had not yet entered this final judgment. He was found unconscious from a drug overdose, and his wife, Khloe Kardashian, was still considered to be his wife with this legal powers of making medical healthcare decisions for him, and still had the power to make life and death decisions on his behalf, even though they clearly were terminating the marriage. And that's what became so controversial. And that's in a case when there's an estate plan. Now let's suppose that the spouses do not have any type of estate plan. Well, you fall in one of two categories in the event of a sickness, right? You may become incapable of handling your financial or healthcare decisions. Well, in that case, guess what? The law comes in and has your spouse as a priority to make healthcare decisions for you during the marriage, even when you have no documents in place. So what happens is that your spouse continues to have control up until the divorce is filed. What happens when the divorce is filed? Under Florida law, nothing. Your spouse remains in control of making medical and healthcare decisions throughout the divorce proceeding up until the final judgment for the divorce is entered. So that's another scary situation where we saw the same thing can happen to what happened to Lamar Odom and his then wife Khloe Kardashian. The same thing can happen when you don't have an estate plan. And then finally, let's suppose one of the spouses dies. Well, guess what? The spouse continues to have control up until the divorce is filed, but that spouse can also inherit everything, potentially, depending on the circumstances, especially if there's no children from any other marriage. The spouse can potentially inherit everything. And that's through the laws called intestate succession in Florida. So the spouse could potentially inherit everything, even though it's perfectly clear that wasn't the intent of the person who died, because you're in a divorce proceeding. But guess again, if the spouse can inherit everything until the final judgment is entered. So I hope this provides an overview of how these issues could play out under Florida law in the event of any sickness or disability or death during a divorce proceeding. So when in doubt, change it out and talk to your attorney about how to go about doing that. So I hope this information was helpful. Thank you again for joining me. And as always, I wish you all good health, stay safe, and to always, always have faith. Thank you.